All right. Good day and welcome. I think we should actually begin now because we do have a full agenda today, and I need to provide you with some introductory remarks. I'm Margaret Jackson, the director of the Freda Center within the School of Criminology at Simon Fraser University. I want to first respectfully acknowledge that Simon Fraser University is located on the traditional, ancestral, and unceded territories of the Musqueam, Squamish, Tsleil-Waututh, and Katzie nations. The webinar is being produced by the Freda Center as part of a project being undertaken for the Public Health Agency of Canada, along with the other Alliance member centers across Canada, which are the equivalent to the Freda Center. And an integral part of the webinar is the learning brief, which you should have received if you registered by Tuesday, and those of you who've registered since that time will receive them after the webinar. In addition, the seminar slides, which you will receive soon once they are translated into French. So before I introduce the panel, I want to explain how we're going to proceed. There will be a question and answer format for the presentation with my asking questions of the panel members. And these questions arise from both the learning brief and the slides, although the slides were not intended to be shown today, but do cover the topics to be discussed and thus serve as resource material, which, for example, can be used effectively as a child rights teaching tool. You will be muted throughout the presentation, but may enter questions using the question and answer function, which means you may enter your questions by pressing the Q&A button in the row of icons at the bottom of your screen. And in the last 20 minutes, we will try to work in questions from those entries, but it's already clear to us that we won't be able to answer all questions. For language interpretation, there is also a button in the same line of icons at the bottom of your screen for French or for English. And finally, at the end, we will provide a link to an evaluation survey for the webinar. All right, so it's now my pleasure to introduce our panel. And we are most fortunate to have with us today a youth, Lauren Irvin, who will speak to her own experiences in dealing with family court matters here in Canada. Her voice is an integral part of our discussion today, and she'll be speaking about sensitive issues which may be triggering for some, in which case you can certainly turn your volume down during the presentation. The Honorable Donna Martinson, a retired BC Supreme Court Justice, which I will subsequently refer to as Justice Martinson. Then the Honorable Judge Rose Raven, a senior BC Provincial Court judge, whom I will subsequently refer to as Judge Raven. And finally, Suzette Narbonne, managing lawyer at the Child and Youth Legal Center in Vancouver, a part of the Society for Children and Youth of BC, who will be interviewing Lauren. As well, Dr. Sarah Yursich, Associate Director of Freda, will be assisting with Sandy and Jenny from SFU Meeting and Events, and Abdul Zaire from the School of Criminology, who provided invaluable help. We finally must also acknowledge the interpreters for today, Violan Tourny and Joseph Caron. Okay, I will start first asking a question of Justice Martinson. Justice Martinson, from where do children acquire rights to participate in family court decisions affecting them, and why are these rights so important?
Thanks, Dr. Jackson. I've been asked to be the person to sort of kick us off on this webinar by setting out some of the fundamental principles of children's rights. So children's legal rights in family law cases stem from both domestic and international law. And these rights include the right to be safe, secure, and well, and free from violence of all kinds in their families. And all children under 18 who are capable of forming their own views specifically have the right to participate in all judicial proceedings that affect them if they choose to do so, and to have their views and preferences taken seriously. That participation right is said to be directly, that's inextricably linked to the determination of their best interests. And understanding that children are humans with independent legal rights is the essential starting point in family law cases. The Supreme Court of Canada recently emphasized the importance of recognizing children as full rights bearers in Michelle and Graydon, a family law child support court proceeding. A judicial hero of mine, Lady Brenda Hale, who, as I'm sure you know, was the former Chief Justice of the UK Supreme Court, captured the role of courts in treating children as such full right bearers. She said that courts should think of the child as a real human being with their own distinctive personality and rights, and not just an extension of the adults involved. So to put that another way, as family law professionals, we often pride ourselves in taking a child-centered approach, which is good, but doing that cannot involve paternalism, an approach which says that children should be kept out of legal processes to protect them, leaving the decision-making solely to adults. This paternalistic approach was the prevailing wisdom for a long time. But as Justice Sheila Martin put it in the Michelle and Graydon case, we have over time moved all the way from treating children actually as property to treating them as full rights bearers. And paternalism was a step along the route, but one that no longer reflects the legal rights of children. And I want to stress the critical importance of the actual implementation of children's rights. Children face challenges knowing about and enforcing those rights and being treated as people with rights. So rather than adults protecting children in the sense of keeping them out of court processes, adults, including professionals working with children, have responsibilities to help children actually implement their rights, generally and in court processes. And I promise that this will be my last judge quote, but I suggest that Chief Justice Robert Bowman of the British Columbia Court of Appeal basically hit the nail on the head in explaining how children's rights should be implemented. He described children's rights, including their participation rights, as meaningless without the means to implement them, and as the role of adults in implementing rights as being about empowerment of children, not paternalism. So I want next to just speak briefly about the legal status in Canada of the United Nations Convention on the Rights of the Child. It was ratified by Canada on December 13th, 1991. So the mathematicians among you will immediately recognize that that means that we will be marking the 30th anniversary of that ratification very soon. The convention is now the most widely ratified convention in the world, and it is considered a really important international convention. And sometimes people misunderstand the status of the convention in Canada and say it is not law because it often isn't directly incorporated in our legislation. Respectfully, that view is not correct. Canada was a leader in creating the convention and has always taken the position that it doesn't have to incorporate it directly because our laws do comply with the convention. The Supreme Court of Canada has emphasized that our laws should generally be presumed to conform to the convention, and the convention has been referred to many times by our courts. The concurring judgment in Michel and Graydon reminded us that as a principle of statutory interpretation, the legislature, Parliament in the case of the Divorce Act, is presumed to take into account Canada's international obligations, and the judgment specifically referred to the convention. This convention and the United Nations Committee on the Rights of the Child that is created by the convention apply a child rights approach to identifying and implementing child rights. And a major role of the expert UN committee is to ensure that the convention is implemented by countries, including Canada. That is to monitor countries' compliance with it. And there are several of these general comments that they've created for that purpose that are particularly relevant to family law cases. They represent well-respected international child rights norms and are really authoritative directions on implementation. For example, General Comment 12 deals with the right to be heard, General Comment 13 with violence against children, and General Comment 14, implementation of the best interest principle. Those general comments have also been referred to by Canadian courts, and Judge Raven and I, in the learning brief you've received, which we prepared, suggest that the UN Committee's general comments should generally be followed. And if they are not, reason should be provided for not doing so, together with an explanation as to how the concerns raised by the committee are in fact being addressed. Just give me a quick moment here. There we are. Article 12 is probably the most well-known convention article, and it's often referred to as the right to be heard. And Article 12 has two parts. And part 1 has two distinct rights, each of which is equally important. First is the right to express views if the child is capable of doing so. And the second, and it's separate, is the right to have those views given due weight in accordance with the child's age and maturity. And then Article 2.2 specifically states that the right to be heard applies to any judicial proceeding affecting the child. General Comment 12 discusses this right in great detail and states that a child has the right to be heard in all matters affecting the child, including any judicial and administrative proceedings. So you'll know that Section 16 of our new Divorce Act states that the court shall consider the child's views and preferences, giving due weight to the child's age and maturity unless they cannot be ascertained. There is no limit on the type of case. The Divorce Act legislative objectives refer to the convention and in particular to Article 12. The Act should be interpreted in conformity with the convention and general comments. So I'm almost done. I've emphasized the importance of implementing rights. And 8 child rights safeguards and guarantees have been identified by the UN Committee on the Rights of the Child as being necessary to implement child rights in court processes. It's important to note that obtaining the views of children is only one of the 8. The others include prioritizing court proceedings and avoiding unnecessary delay, establishing relevant facts, including those relevant to the child's views, using well-qualified professionals, using appropriate legal reasoning, ensuring that there are mechanisms to review or revise decisions, using child rights impacts assessments, and I emphasize this, affording all appropriate legal representation when a child's best interests are being formally assessed by courts. The legal reasoning safeguard requires judges to implement children's rights in their decisions, and children's lawyers have an important role to play in making submissions about that and in assessing the decision for legal correctness. So as I've mentioned, you have a copy of the learning brief Judge Raven and I prepared, which provides details of the convention child rights approach and the safeguards and guarantees. And it also has a practical guide or checklist as part 2 to assist you with applying the convention and safeguards in your day-to-day work and in making appropriate submissions to the court. Thanks.
Thank you, Justice Martinson. I'll direct the next question to Judge Raven. From your perspective, why is it important to implement children's rights in all family law cases?
Well, thank you, Dr. Jackson, first of all, for inviting me to participate in this panel on the very important topic of children's rights. And secondly, Justice Martinson, for your very comprehensive summary of the UN Convention on the Rights of the Child, which is a document, as you've mentioned, Canada played a leading role in forming and signed on as a signatory in 1991. From my perspective, it is important to implement children's rights in all family cases because this is an important access to justice issue. Not only are children's rights informed by the United Nations Convention on the Rights of the Child, children also have the full protection of Canada's Charter of Rights and Freedoms. Justice Martinson alluded to the British Columbia Chief Justice Bowman's address in 2017 on the topic of why access to justice for children matters. And I think it's important to note that he emphasized then children have the right to be protected and empowered because these are the cornerstones of a just society. He also explained that children are entitled to the full protection of the Charter. And of course, under the Charter, there is no discrimination based on the age of the children. Implementing children's rights is also clearly in the best interests of children, and that is the governing factor in deciding family law cases. As stated by Justice Martinson in the case of BJ versus GDL, a 2010 decision of the Yukon Supreme Court, commonly referred to as the BJG case, many children want to be heard, they have a right to be heard, and hearing from them can lead to better decisions. This case has been cited by other courts across the country, including recently in the case of Medjic and Medjic, a 2019 Ontario Superior Court decision at paragraph 32, where it states, if the child is capable of forming views and communicating them, then generally she should be allowed to express them in a judicial proceeding affecting her interests. The case of BJG has also been referred to favorably by the UN Committee on the Rights of the Child in its last concluding observations about Canada's compliance with the convention. In order to implement children's rights, their participation must be meaningful. The case of BJG states that meaningful participation has a number of elements. They include informing children at the beginning of the process that they have legal rights, giving children the opportunity to fully participate and have a say in how they participate, having their views considered in a substantive way, and being informed of the outcome of the proceeding. It is important to keep in mind that children have legal rights to be heard during all parts of the court process. When a child's custody is an issue in a legal proceeding, federal and provincial legislation make it a requirement to consider the child's views. Therefore, in child custody cases, all parties should consider at the time a court case is commenced how the child's views will be placed before the court. Lawyers for parties play a particular role in addressing their minds to this issue at the outset. I find that often this issue is addressed late in the court proceedings, and it becomes necessary to delay a hearing or trial in order to obtain the child's views, or a judge is asked to proceed with the trial without properly hearing the child's views. In either case, the child's best interests can be negatively impacted.
Thank you, Judge Raven. The next question is to Suzette. You have a great deal of experience representing children in family cases. Are you able to speak to the perspectives of young persons on their participation in family court proceedings?
Well, I'm going to do that to start with by introducing you to Lauren Irvin. So Lauren was introduced to the world of advocacy work through her own experiences in the family law system, whereby she retained a child lawyer when she was 13 years old. She worked as a youth co-researcher for a partnered project between In With Forward and the Representative for Children and Youth of British Columbia before joining the Youth Voices Initiative. It was during this time that she was a guest lecturer at Emily Carr University, and she participated in the Child and Youth Champions Conference hosted by the Representative Children and Youth of BC and Access to Justice BC. Currently, Lauren is pursuing a bachelor's degree at King's College in London, so she's joining us all the way from London. Thank you so much, Lauren, for being here. I understand that your family went through a legal separation when you were quite young. Could you tell us about that?
Yes, of course. My parents separated when I was very young, although the official divorce process took several years, as it normally does. My sister was between the ages of 3 and 5, and I was between the ages of 5 and 7 when this was all underway. And during this time, my father actually sent a letter to Child Protective Services claiming that if my mother was given custody time of us, there would be a child homicide case on their hands. And Child Protective Services actually deemed that there was a high enough threat of harm that we were instructed to leave the province without my father's knowledge for some time. And in our case, we also had a Voice of the Child report done. And despite some red flags showing up about my father in the report, they ultimately concluded that my parents should have equal custody. And that's what happened. My father got us 3 days of the week, while my mother got us 4. And it's the closest thing you could have to 50-50 custody within an odd-numbered week. And under my father's care, my sister and I experienced abuse, both emotional and physical, as well as neglect. And some years later, when I was 10 years old, several complaints had been issued against my father. One was from a counselor, a psychiatrist, and then one was from another parent at our school. So ultimately, a social worker was sent to interview my sister and I, but the process was done really poorly, and it didn't include meaningful child participation. I was at school when this happened, and I was called up to the principal's office. I was in grade 5, 10 years old. I was very scared. And there was a man wearing a black suit and carrying a briefcase, and he appeared very intimidating and unfriendly. And he would not tell me why he was meeting with me or who he worked for, who he was, what the information he was getting out of me, where that was going, no matter how many times I asked and pushed for some sort of understanding. And because he didn't open up to me, because he didn't let me feel included in the process, I didn't actually feel safe to come clean with him about the abuse that I'd been receiving. So I lied. I said everything was fine. And ultimately, he concluded the same, and our case was closed. And about 3 months, 2 to 3 months later, after he did that, my father actually gave my sister a head injury that was so severe that she now has lifelong whiplash disorder, chronic pain, neurological issues, and problems with her eyesight from that impact. So clearly, everything was not as fine as the social worker concluded. And all of that leads me to when I was just a few months shy of turning 13 years old. I'm now 18 as of a few days ago. And at that point, when I was 13, I decided to leave my father's house without warning, and I never returned.
Wow. I thank you so much for sharing that. I know that at some point you did get a lawyer. Can you tell us a little bit about how that happened?
Yes. Well, I was 13 at the time, and I had recently left my father's care. And so he decided to retaliate, and he brought upon a storm of legal accusations against my mother, accusations of parental alienation, that is. I apologize for the noise. There's a car blasting music going off my window, if you can hear that. But my mother was really worried about being seen, being perceived as actually alienating us. So she didn't want to include us in the matter. She didn't even tell us that this was happening, that my father had alienation accusations against her. And she tried her best to combat my father on her own, but it was really hard for her to accurately represent the experiences that we had under our father's care without actually including us, without actually talking to us. For instance, she would mention an event that happened that my father carried out, but she would prescribe it the wrong date. And because of that, my father had the leverage to call her out on it. So months passed of this and nothing was being done. There was no progress. And eventually my mom came forth and she revealed everything to us. She revealed that she was currently going through some litigation with my father. And she also decided to show us the Society for Children and Youth of British Columbia, a place that she'd come across on Twitter one day. And she suggested that we get legal representation. And she in no way forced it on us, but my sister and I were more than willing to go through with it. And that's how I gained a child lawyer at the age of 13, not because it was court ordered or suggested by a legal professional, because it was an organization that my mom randomly scrolled across on social media one day. And that's how I got that. And that's what ultimately helped me and got me to the place I am today. And I'm so grateful for that.
Thank goodness for Twitter.
Yes.
So what was your experience once you had counsel?
First, as I've just said, it was one of the best things that ever happened to me. And I mean that with all seriousness. I don't know where I'd be right now if I hadn't had access to a child lawyer. And what my sister and I did is we inserted ourselves into our parents' legal battle. And so now we could directly respond to our father's alienation accusations, which were initially directed at our mother. And so this obviously hurt his case, and he ended up actually withdrawing the day before we were scheduled to go to court. But unfortunately, it wasn't that simple. My father then created new alienation charges. And then he also tried to force a court-ordered reunification program for us. But again, my sister and I did what we did before, and we used our child lawyers to bring ourselves into the picture once again. And my father withdrew shortly before we were scheduled to go to court again. And he did this several times, all within the span of 1 year. And he did this because he had the money to bring one claim after another, and string things out forever. But ultimately, he tired himself up and gave up for good. But the process was handled so well by my lawyer. She explained everything to us, and she made sure that we were informed about what was going on, something that had never happened to my sister and I from someone in the legal system or child protective services ever before in our lives. It was so refreshing. And before my lawyer even sent letters out on our behalf, she made sure to run them by us in order to make sure she was presenting our views accurately. And because of this, I felt safe, I felt heard, and I felt fully informed about all the proceedings going on. But I think above all, what truly stands out to me about this whole experience is how empowering that process felt for me. For years, I'd been a scared kid under my father's care. It was all I'd ever known. And I never got the chance to tell my side of the story, to talk about the things that my father did. And through my lawyer, I actually gained this opportunity. And I felt confident, and I felt empowered, and I felt like my voice meant something for once. So it was also a moment of healing for me.
That's totally amazing. Lawyer question, did you get the outcome that you wanted to get?
Well, that's a difficult question to answer. And I'm going to be entirely honest and say I don't really have a solid answer for that question. It's a yes and a no at the same time. And because when I first sought legal representation, I was thinking purely short term. I wanted to stop my father from going after my mother with alienation charges and forcing a reunification program. And that happened. We succeeded. But despite my father stopping to engage us legally, he still was able to insert ourselves in our lives in many other ways that we did not want. For example, he and his extended family still regularly to this day, when I'm living on a different continent, send me emails. And when I block their accounts, they create new ones to contact me. I also, at my old address, received physical letters in the mail, despite multiple attempts to block them at the post office. And of course, the contents of these messages are never friendly. It's harassment, and for the past 5 years. And most of my time in the family legal system was spent taking the defensive approach and reacting to my father's actions, rather than taking the offensive and trying to actually hold my father accountable for what he'd done. And I did want to make legal motions against him from when I was as young as 13, and I first got my lawyer. And I discussed this with her. We spent years mulling it over, trying to decide if it was worth the risk. We came back to the idea only to discard it again and then come back to it again a couple years later. Because if my father looped my mother into the process, then she'd be forced to pay for her own lawyer, which almost bankrupted her the first time after my father tried to, take her to court and then dropped it and take her to court again and again and again. So we couldn't risk it financially. But what I really wanted was to amend my parents' divorce order, which still states that my sister and I should be with him 3 days a week. I wanted to legally change my surname for years, which I only got to do earlier this year because I couldn't do it without his written consent. I wanted him to help contribute financially to the private school I was attending at the time. I wanted him to pay for the physiotherapy sessions my sister still has to undergo for an injury which he caused. There was also medical and school privacy. And then even looking into paying damages for what he did to my sister and me. The list goes on and on and on, but it was all too risky to try it. So in the end, I do feel unfulfilled with what I've done in the legal system, but I'm also very, very grateful for the things that I have managed to achieve.
Thank you. So tell us, what made you decide to share this with us today?
Well, firstly, I want to vouch for the importance of child lawyers. It's a service that I think should be widespread knowledge for all children in the system. And thinking about the fact that it was sheer luck that my mom randomly managed to stumble upon a post on social media. That's how I got a child lawyer. That's how I ended up where I am. And my heart goes out to all the other children who didn't know that this was an option. So I think that's really important. And I think it's really important for there to be representation for historically underrepresented groups within the legal system, such as children and youth, especially in projects or research studies or conferences like today that discuss their rights and pertain to their rights and to their futures. And as someone who's experienced both sides of the spectrum, both poor and quality child participation, I can say that there is a tremendous and very recognizable difference when children aren't kept informed about the legal proceedings that are currently underway in their lives, and ones that are very entangled in their well-being, their mental health. It causes harm. It does. So that's what I wanted to make known for everyone here today.
Thank you so much for that. That was amazing. I suspect people will have lots of questions for you at some point.
Well, I'm glad to be here today. Thank you.
Yes, thanks very much, Lauren. It was wonderful to have you share that with us. So a question then back to Suzette. Is it clear that young people like Lauren want to participate in legal proceedings that affect them? Can you describe how a child can participate in a family law case and how the court process actually benefits from that participation?
So there's any number of ways that a child can participate in the legal process, and using one does not exclude using others. There could be a neutral third party, such as a social worker or a psychologist, who can present the child's views. In British Columbia, where I practice, these are generally done through something called a Hear the Child report or a Voice of the Child report, or commonly called a Section 211 report, because that's the legislative, where it comes from in the legislation. These reports can be evaluative or non-evaluative. And the big distinction between those is a non-evaluative report records what the child thinks is important for people to know, and then provides that to the decision makers. So it allows the child to effectively participate without attending court. When you look at an evaluative report, that's more of an expert's opinion as to what they say is in the child's best interest and what that child's parents' capacity is to meet the child's needs. It does tend to include the child's views, but it will also weigh the child's views. Unlike a non-evaluative report, the child will almost never see that expert report, and they won't know how their views were shared. They won't know what weight the expert gave their views. So when I get a young person who I'm representing and there's been a 211, I can say to a person, they have never seen what the expert claims they had told the expert. And they can sometimes be somewhat dismayed. In my view, the court can definitely get some valuable information from one of those expert reports on when they're determining what's in a child's best interests. But the court doesn't necessarily have the benefit of knowing what the child thought was important for the court to know. Now, other ways a child can participate is through the hearsay evidence of a parent or a trusted adult, or through the evidence of a lawyer. And that's going to depend jurisdiction to jurisdiction. In some jurisdictions, the children's lawyer is permitted to provide the court with a summary. In some jurisdictions, they cannot do so, and so they rely on other evidence to do that. A child can also participate in a judicial interview, and again, that depends on the court's practice. Some courts have heard a child through the child's own affidavit, or even through the child giving viva voce evidence, so attending court and testifying. Where I work, our practice really forbids those kinds of things. I can't think of a case where we've relied on a child's affidavit or where we've called a child to give evidence in what is their family case. I think that what's most important is that the child or the young person, and I'm sorry I keep saying child, but really it's a young person, is given the opportunity to choose how they want to be involved and decide what level that involvement is going to be, and to decide whether they want to participate at all. And they also should know, like Lauren said, what views are being ascribed to them. You've asked me about the benefits to the process, and I think there's benefits to the court and there's benefits to the young person in hearing from the child. So what you find is you can reduce the conflict between the parties, because sometimes the parties believe the child is trying really hard not to hurt their parents. So they may tell one parent one thing, the other parent something completely different. So when the children's lawyer can say, this is what your child wants me to share with both of you, you can really help reduce that conflict. Hearing from a child is going to promote better decision-making, it empowers children, and it enhances their confidence and self-esteem. Now, there's always also benefits to the decision maker. And one of those is that putting the child at the center helps refocus everyone on what is in the child's best interests. Our experience where I work is that most of the discussion we're hearing is about the argument between the parents. When I'm in court, I'm hearing their argument. We can be days of evidence and barely know anything about the child. So when you work for the child and with the child, you can do a really good job on refocusing everyone back to what is important for that child. The other thing I would say is that it's easier to make good decisions when you have a better understanding of what's important to the child. A decision that includes the young person's voice tends to be more lasting. So there's less going back to court when that happens. Often when you include the child's perspective, and I think I've sort of suggested this, it's just easier to get buy-in from everyone and avoid the trial altogether. When there's a lawyer for the child and the children's lawyer introduces the child's evidence in any number of ways, it gives that decision maker a larger, better, and more informative picture of what is important to the child. And I just want to end this question by saying that when children are involved and they have a lawyer and they feel that their views are actually important, those children are empowered. They feel more satisfied, their confidence grows. Social science tells us they have more self-esteem when they're allowed to be actively involved in the decision-making process.
Oh, yes. Thank you, Suzette. And thanks again, Lauren, for sharing that with us. The next question goes to both Justice Martinson and Suzette. And part one to Justice Martinson. Should children participate in family law proceedings when alienation is alleged?
Wow. Well, I think Lauren has just answered that question much better than I can, but I would like to provide some legal context for this fairly quickly. My answer is yes, in that they have the same rights to participate as all other children, and they can't be placed in a special category which denies children in alienation or sometimes family violence cases or both, just because of the nature of the case. Seems that sometimes if there's an allegation of parental alienation, some decision makers refuse to hear from children right at the start of the case just because of the allegation of alienation. And in my very respectful view, doing so can inappropriately prejudge an ultimate and central issue, which is whether there is, in fact, alienation. We heard Lauren talk about wanting to speak about that very issue. And there are many reasons why a parent-child relationship might break down. Family violence is a significant one. Children have important information and views about both alienation and family violence. And preventing them from participating, especially right at the outset, can not only prejudge critical issues in the case, but also silence children like Lauren on questions so critically important to their lives. And it also deprives, as in Lauren's case, women and the courts of critical evidence in reaching a fair, just, and equality-based outcome. And I suggest that the convention and Canadian case law can be helpful in making arguments about children and their participation in these kinds of cases. Article 1 of the convention is very clear that a child means every human being below the age of 18. So that means it applies to all children, no matter what age and type of case. And Article 19 specifically protects all children from all forms of violence while in the care of others. And in order to do that, we need relevant information about violence from those most well placed to provide it. Article 19 specifies that violence includes all forms of physical or mental violence, which is consistent, of course, with the inclusion of psychological or emotional violence in our new Divorce Act. And you'll recall that one of the safeguards I mentioned is obtaining relevant evidence. Having the necessary information about violence, including information from children, is essential in determining whether there's family violence, and if so, what its impact is and what the outcome should be. Article 9 of the convention deals quite appropriately with the right of the child who is separated from one parent or both to maintain personal relations and direct contact with both parents. But it's also important to add that it very clearly says, except if it is contrary to the child's best interest, which really is the critical question. So general comment 13, the one about violence specifically, deals with these issues, and the Committee on the Rights of the Child there makes these three, I suggest, very important points in this respect. The child's right to participate has particular relevance in violent situations and commences with very young children who are particularly vulnerable to violence. Second, you can't promote the full set of rights in the convention unless you respect children's human dignity and physical and psychological integrity. And the third one, and I emphasize this particularly, an adult's judgment of a child's best interests cannot override the obligation to respect all of the child's rights under the convention. So I'll just quickly say that Judge Raven mentioned the BJG case, the Yukon case, that does say that the convention doesn't make an exception for cases involving family violence, alienation, or both. She mentioned the more recent Ontario Superior Court case in Medjuk, and there the court said pretty clearly a child capable of forming views and expressing them should generally be allowed to do that no matter what the type of case, and including family violence and alienation cases. And the focus will usually be on the weight attached to them.
So now part 2 for Suzette. Lawyers and judges sometimes say children should not participate in these kinds of cases. What is your own opinion and experience in that regard?
So I agree 100% with Justice Martinson that children should be permitted to participate regardless of whether or not there are allegations of alienation. And there's no doubt that some judges are reluctant to appoint a lawyer for the child when they think there's a possible or a likely case of parental alienation. But my personal view as a children's lawyer is that this is when the child probably most needs legal advice. Some pretty extreme measures can result when a court ultimately determines that a child has been alienated. And so to leave that child without a voice simply because they've been subjected to what I would call very poor parenting is not consistent with a child rights approach.
Thank you. Thank you to both Justice Martinson and Suzette for that one. So now back to Justice Martinson. Can you speak to the interplay between a child's wishes and that child's best interests?
Sure. This is another area where our thinking has evolved really from never taking wishes into account to now taking those wishes more and more seriously. We have a ways to go yet, obviously, but a significant turning point, for me at least, was the 2009 Supreme Court of Canada decision in AC and Manitoba. And the sites are in the learning brief. Justice Abella stated there that at some point in time, if a child is sufficiently mature, the child's wishes become the overwhelming factor in determining what is best for the child. And then since then, in 2014, the UN Committee on the Rights of the Child released General Comment 14, which focuses, so in 2014, General Comment 14, which focuses specifically on the best interests of the child. And Judge Raven and I deal with this in some detail in our learning brief. But here are some of the key points in response to this question. I've already mentioned the inextricable link between Article 12, the right to be heard, and Article 3, the best interest section. Also, there should be no age limits, and capacity should be assessed on a case-by-case basis. There's a presumption of capacity. It's not necessary to that the child have comprehensive knowledge of all aspects of the matter affecting them, but that there is sufficient understanding to be capable of appropriately forming his or her or their own views. And again, the views of the child have to be taken seriously when the child is capable of forming their own views.
Thank you, Justice Martinson. Now to Judge Raven. The best interest test is discretionary. So how does that affect how you weigh the views of a child? You need to open your mic.
I'm so sorry. I was just saying that in the interests of time, I'm going to try to keep my response brief because we do want to leave time for questions and answers. As has been stated, the child's views are one factor a court considers in determining what is in that child's best interests. And as Justice Martinson has pointed out, the Supreme Court of Canada case has already indicated that a child's developmental age and maturity impact the weight to be placed on that child's views. Following up on that decision, the effect of age and maturity on the weight to be placed on a child's views is also addressed in the case of RG versus KG, a 2017 Ontario Court of Appeal decision at paragraph 67, where it is stated, the degree to which the court will follow the wishes of the child will depend upon the age and level of maturity of the child and will be subject to the judge's discretion as she seeks to determine the child's best interests. This was cited with approval in the Medjic decision, which I've referred to, and so has Justice Martinson. In summary, I say the views of children are given significant weight if they are formed by mature children in a reasonable and independent manner. In addition, a judge will consider whether there is other evidence that supports the children's views.
Thank you, Judge Raven. Back to Suzette. What is the children's lawyer's role in bringing evidence before the court in support of the child's views? And is there any obligation to inform the court of evidence that is contrary to the child's views?
So as a starting point, I'd like to say that in the work that we do at the Child and Youth Legal Center, we represent young people on a solicitor-client model. So what that means is that relationship between the client and the lawyer is protected by solicitor-client privilege, and we only will take any action based on the child's instructions. There's lots of good reasons we do this. For one, it accords with the child rights approach. Supporting a child's views and recognizing their right to be heard in a way that really advocates for their point of view. We take instructions from our client, the child. And I think one of the really pivotal points about this solicitor-client relationship is that it allows that all our communications are privileged and confidential, just like any other lawyer's role with a client. Our files, our conversations, our briefs, our notes, all of those are confidential. And that allows our client to feel confident in having their discussions with us and confident in knowing that their views are being taken seriously. I know we've heard a lot about Justice Abella. She's written so many amazing things on child rights. And I think she said it best in a case called RW when she was sitting as a judge of the family division of the Ontario Provincial Court. So she had a case with where there was a 7-year-old child who had been appointed to have her own lawyer. And I point that out, 7 years old, but quite rightly had been given the opportunity to have counsel. Her lawyer, it was a child protection matter, and her lawyer decided that the lawyer's approach would be to tell the court what the lawyer thought was in the child's best interests. And that was their way of representing the child's views. The child's mother, not surprisingly, took issue with this, and Justice Abella was called on to give some guidance as to what the role is of the children's lawyer. And she said this: I am persuaded that essentially the role of the lawyer for the child is no different from the role of the lawyer for any other party. He or she is there to represent a client by protecting the client's interests and carrying out the client's instructions. At the same time, the lawyer is an officer of the court and as such is obliged to represent these interests in accordance with well-defined standards of professional integrity. She also confronted the expectations people have of the children's lawyer, where they assume that in order to be an effective children's lawyer, that lawyer needs to be a paragon of legal and psychological and sociological expertise. Obviously, this is not very realistic. Lawyers generally have legal skills that are obviously going to be informed by other disciplines, but at the heart of it, a lawyer is called upon to exercise legal judgment. That is their area of expertise. It's interesting to note that Justice Abella, back in that decision, which I think is from 1980, talks about, well, certainly doesn't endorse the courtroom as the best place to decide family law issues, but she says that's where it's happening right now, and says as long as the forum is the courtroom, the child's lawyer should represent his or her young client in a way that reflects equal participation with the other parties in this forum. Now, I know you've asked me how a lawyer does this in an ethical way. And what they do is they do that by acting as they would for any client. They execute their client's instructions without being misleading. And they attempt to show through the evidence that the court has that the instructions or wishes actually match the child's needs. So they advocate for the child. They don't substitute their client's instructions for the lawyer's own view of what's best for the client. They do their best to ensure that their client's views are freely given and not with duress. And at the end of the day, the children's lawyer has to give the best legal advice they can to help their client come to a good decision and to enable that client to give their lawyer good instructions. And I think you heard that really clearly from Lauren when she talked about her work with her lawyer and the years of back and forth and trying to decide things and weighing the pros and cons. That's what a children's lawyer should do, is treat their client like a client. I think it's important to remember that the children's lawyer is not the only person involved in the case. There's many people who are going to be more than happy to tell the judge what they think is best for the child. And that ranges from the parents to their witnesses to experts who will present their opinions to the court. And at the end of the day, it's the judge's job to decide what is best for the child. I know it can be challenging in theory because as adults, we are so used to thinking of children as people whose views we may take less seriously than that of an adult. Frankly, what I've found in representing children, and I've been practicing law for over 30 years, and my experience is that children often express the clearest views of any client that I've ever had. So it's actually really easy to act for children in an ethical way and to get clear and consistent instructions.
Thank you, Suzette. Okay, the next question is for all. And the question is, what are the consequences of not hearing a child's views? We'll start with Justice Martinson.
Yikes. I want to fairly quickly, I see, looking at the time, just speak about two concerns that are often raised with respect to children and legal representation, because I think it goes to the point that some people think we shouldn't be hearing from them, even though we've heard all these benefits. So some legal and other professionals express concerns that allowing children to participate puts them in the middle of the conflict. That can be harmful. And they also suggest that a lawyer for children puts the child or young person in a confrontational position with at least one parent, and that can damage future relationships within the family. I've had a chance to address these concerns with Katerina Tempesta, who is a senior and very experienced lawyer with the Office of the Children's Lawyer in Toronto. That was in an article published in the Canadian Journal of Family Law back in 2018 called Young People as Humans in Family Court Processes. And there we respectfully suggest that if done in a manner sensitive to child's particular circumstances, including their age, maturity, and social context, it really affords children the opportunity to participate in ways which won't harm them and expose them to further conflict, which is what we've been hearing both Lauren and Suzette say today. And we've also heard some of the other benefits. But on the question of a lawyer, a child's lawyer taking a confrontational stance on risking family relationships, we suggest that this concern fails to consider that lawyers have professional obligations to act with courtesy and respect in the courtroom. And we've heard about then Judge Abila's case in Re W, and she emphasized there that the lawyer is an officer of the court and is obliged to represent their interests within well-defined professional standards of conduct. So finally, we note, and I feel very strongly about this today, one must be cautious about equating the negative effects of parental conflict with children's rights to have their voices heard and be adequately represented in family law proceedings. Usually, and again, as we've been hearing, the causes of difficulties in family relations generally go much deeper than that and shouldn't be a justification to deny to children meaningful participation and just outcomes. The overarching goal is to achieve a fair, just, and equality-based decision about the children's best interests within the best interests of children, within this child rights framework, and legal representation when cases are within the court process is a very important way of achieving that. Thank you.
Thank you. Judge Raven.
There I am. The consequences of not hearing a child's views in a custody dispute are clearly that a judge is being asked to decide a child's best interests without properly hearing from the most important person in the case, and that is the child. Lauren, when you described how at the age of 13, you left your father's home and never went back, it reminded me of a case I heard within the past 2 years, which was a very high conflict case involving allegations of parental alienation and family violence. And at a morning break, the parents had multiple telephone messages from their 11-year-old child's school saying that their child had left the school premises and had not returned and could not be found. I had to stand down the proceedings. There was an Amber Alert issued, and this child was found many hours later, having spent the entire day and well into the evening simply riding buses all over Greater Vancouver. And it occurred to me that this was a child that clearly required an independent voice. And although neither parent nor lawyers requested that the child have a lawyer, I made a referral to the Child and Youth Legal Center to have representation for that child. The BGJ case that has been referred to several times this morning at paragraph 21 says, obtaining information from all children, including younger children, can lead to better decisions that have a greater chance of working successfully. And as I've indicated before, receiving the children's input early in the process and throughout is appropriate to reduce conflict by keeping the focus of the proceeding on the child and what is important to the child. In short, it's my view that not hearing a child's views leaves a significant gap in a judge's ability to assess that child's best interests, and it also negatively impacts the well-being of the child.
Thank you, Judge Raven. Suzette.
I'll just add really briefly to what Judge Raven and Justice Martinson have already said, and that's all children need to be heard regardless of their age, but particularly when you're thinking about a teenager, in order for a custody order for a child in their teens to be practical, it has to conform reasonably with their own wishes. I think anyone who has a teenager or who has been a teenager knows this and can relate to this. If children aren't listened to, there's a concept known as voting with their feet, which of course is what Lauren did and what we often see. And the child then goes and does what they feel the court should have done. We often find where I work that a teen will come in and their parents have been in court forever, and not once has that person been asked, that teenager been asked, what their views are when parenting plans are being made. So there's definitely a need to hear the child and a consequence when you don't.
Thank you. I'm going to ask the panelists at this point whether I should proceed with the last question, since they're given the time.
My suggestion is not, because there only is a couple of minutes left until we're in the 20-minute time frame. Perhaps the issue will arise during the course of the questioning. Do the others agree with me?
Yes, that makes sense.
Okay, great. Well, thank you very much. And before starting the questions, though, I do want to first thank all the panelists for participating, and especially Lauren for sharing her story with us. I think you really made the issues come alive for us, Lauren, in a very clear and compelling way. So it's much appreciated. And so as we heard, the importance of recognizing children as full rights bearers in all family law cases and the importance of implementing child rights is of great import and linked to determining their best interests. So we turn to the questions. Here, let's just do the Q&A. Here we go. Right. Yeah, how do I, oh, here we go. I'll start here. I think this may be more of a comment, however. I'll move to this one and answer live. I'll read the question. The question is this panel concerned with the rising number of cases that result in forced reunification? and the example in parentheses, Family Bridges program that requires a 90-day no contact order. These programs do not have any documented success, and judges have limited information on the methodology. The trauma of forced separation is not even a consideration, and children's views are dismissed. Their rights are being ignored. And I think I hit that, right? Oh, you got it. Okay. So panelists, who would like to speak?
If I could start really, oh, I'm sorry, Dawn.
Well, no, mine will be quick. Yes, very much so.
Oh, yes, Suzette. Okay, now you can go.
100%. We talk about it in our office quite often. I think there should be some longitudinal studies that see what is the impact on the child down the road when they're forced into these kinds of programs. So yes, 100% I agree with Justice Martinson.
And my comment is that I've been asked to make those types of orders a couple of times and I've refused, because sometimes the process that the child goes through seems much more traumatic than what everybody's trying to solve in the issue.
Okay, the next one. First, it starts, thank you so much for this informative webinar, and a special thank you to Lauren on her courage and bravery for sharing her lived experiences. The question is, and you'll probably understand okay. What are your thoughts, recommendations for getting the VOC involved in upholding children's rights to participate in FC in cases involving silent and subtle cases of coercive control, emotional, financial abuse, where there is no forensic evidence or physical abuse, which are countered by the abuser who retaliates with malicious and false claim of PA? How much weight do judges give to current academic research by PA on leading experts such as Peter Jaffe and Linda Nielsen, Simon Pierre, and John Meyer? So it's bringing in the issue of silent and subtle cases of coercive control, emotional and financial abuse, where there is no forensic evidence for physical abuse.
I'm laughing not because I in any way think the question is funny. The questions, they're extremely important ones. We could spend a whole day or longer talking about them. Dr. Jackson, you and I tried to address some of those in our earlier learning brief about statutory interpretation. But I think I can say and have written about the fact that I have concerns about how issues, and I say this with great respect to people who have views otherwise, but I'm very concerned about things like the wide circulation of lists of indicators of parental alienation that have been widely spread and in some ways are part of education programs without the same kind of emphasis being placed on domestic violence and its importance and its widespread complex nature. And there is a concern in looking at how some cases unfold and then also listening to people who advocate for women, that allegations of domestic violence can be minimized or silenced, and that views that could be indicators of course of controlling violence are too quickly viewed as indicators of alienation without a proper analysis of all of the circumstances. So that's a significant concern, one addressed by many people, but I can refer to a recent report here in British Columbia by the Rise Women's Legal clinic, which operates in conjunction with the law school at UBC, which has interviewed many people and supports the concerns that I raise. So I hope that's at least somewhat responsive to the questions.
Sorry, I'm just trying to scroll back up here. It's not scrolling very well. This is a short question. Justice Martinson, why do you accept the language of wishes when we are usually talking about a young person's opinion? Wishes connote something very different, particularly to young people.
Yeah, good. That's a good question. I actually thought about that recently as I was looking at this. Sometimes it's just because that's the language used either in the question that's been posed. But even the Divorce Act itself speaks about views and preferences. So perhaps preferences is a better word than wishes, but I think courts want to know what young people may prefer. And we sometimes get focused on sort of generally about which parent they want to live with most, but preferences can relate to all sorts of issues. Where do they want to go to school? How much time do they want to actually spend, no matter who has the overall majority of custody? So that's my response. Thanks.
Thank you. Thank you. This one is, I'll combine two. Suzette first. Good morning and thank you for this conference. I'm wondering if Suzette can comment on Section 8 and the positive requirement of counsel to advise clients that orders regarding the care of children must be made in the best of the interest of the child only. Is this happening?
Well, I would say, unfortunately, I'm not seeing it, but bear in mind that I'm only seeing the things when they're going sideways. I'm still, unfortunately, seeing agreements between parents that one parent is now seeking to uphold or enforce is a much better word, where the child was not even asked their views. What I'd love to see, if I was entitled to tell people what to do, I'd like to see something that actually required an assertion that it occurred, that the best interests of the young person were considered, and also how those were considered. So it's not just ticking off a box.
Right, thank you. Okay. Can a parent or the parent's lawyer request that the child be appointed counsel, or does the child need to request this on their own? Suzette?
The answer is either. Our practice where I work is that one of the parents has to do it, and that's only because we just don't have the capacity to do it ourselves. I would love to see, but a child certainly could make an application, and in a decision in British Columbia where a child was not appointed counsel, the application was initiated by the child. So it can be the parents, it can be the child.
Thank you. Okay, this one's for Lauren. I'd love to know if Lauren has any comments on the last question around consequences of not allowing kids to participate. And that's combined with the next question, which in essence asks the very same question again of Lauren.
Right. I think that it's very, very important that children are heard. And if I didn't have the opportunity to be heard, I might have very well ended up doing a reunification program with my father. I might have even ended up in his custody once again. And who knows what would have happened to me then. So I think by not including children's voices, you could put them in very, very dangerous situations. So I think sometimes it's even at the case of in the most severe situations, life or death. So I think it's very, very, very crucial to include child voices because it's very dangerous if you don't.
Yes, thank you. Actually, there's another one for you, Lauren. Thank you for all your sharing of wisdom, especially you, Lauren. Any tips on how counsel for a parent can convince a judge that a lawyer should be appointed for children when there has been a Section 211 report done in a case when the assessor has effectively said they do not believe what the children have said about their treatment by one of the parents?
Well, I'm not a lawyer, so I'm not sure the extent I can discuss that specific situation. But I do know that me having a lawyer was very disagreed upon by the opposing party. In fact, my father's lawyer would not even communicate to my lawyer. He would communicate directly to my mother's lawyer, who would have to send the message back on to my lawyer. It was like a game of telephone. And so I think it's very, very difficult trying to try to convince other members in your legal situation that children should have access to legal representation. It's very difficult, and it's always very important that you have a judge that agrees with you on that, and that's not always the case. So
Thank you. Actually, that was very well done. Okay, one more question here. It's a bit different. This information has been enlightening. I'm grateful. Is there any advice on how to apply or action any or all of these ideas if one does not have access to huge amounts of money? That is, how does one navigate the substantial financial barriers to low-income earners trying to protect their children? Suzette?
In British Columbia, our services are free. I think across the country, any child representation, the government funds, not exclusively, I mean, people can also fund it themselves, but in most of the provinces where they have child representation, it's provided either through a government program or with us, we're a not-for-profit, not a government program. And that's exactly for the reason you've identified there, which is you shouldn't have to have tons of money to protect a child and to represent a child's interests. So short answer, but yeah, it tends to be available without cost to people. In our office, the child can just call us.
Well, I'm not sure
Margaret, may I just make one
Of
follow-up?
course. Yes, I can't see you.
about that,
Sorry,
please.
Justice Martinson, you're covered with
No,
the
that's
block. Okay.
fine. I agree with what Suzette has said generally, but most of you who are listening will likely know that the availability of free legal representation varies greatly across the country. And Suzette's office is fabulous, and while the office is developing rosters, you have 4 staff lawyers, and it isn't government funded. It's funded by the Law Foundation, or it may be partially government funded. No, it seems not. Unlike, for example, the Office of the Children's Lawyer in Ontario, children don't qualify for legal aid in family court cases. In British Columbia at the moment, not even in child protection cases, with some exceptions, that there are moves afoot to change that, for which I am grateful. So the question that was asked is a really, really important one, and it's one as a society and as people who are concerned about children, we really need to address further. That's a very good question.
Well, oh, sorry. Were you finished? I'm sorry.
Yes, I just said it was a good question, and it's a concerning
Yes,
question.
definitely. I would emphasize that for sure. Okay, we did see the, did everyone see that? The attendees get that?
Yes.
oh, the evaluation survey, that should be the showing of our last slide, please. Yes, yes, the evaluation survey, that's very important. But I do want to thank all the panelists and all the attendees for your questions. I personally enjoyed this exercise and this experience, and I found it to be most informative and helpful. And I feel that this has been very valuable in terms of getting information out, and this recording will be available on the FREDA website in due time, hopefully shorter than later. So I'll leave on that note unless there are any other comments from any of the other panelists. That's it. All right, thank you so much. Goodbye.